Good afternoon and welcome to the Appellate Division, First Department. Happy New Year to everybody. My notes here reflect that we have over 6 hours of argument time requested for today. So I will have to ask you to please limit the time you request to just what you really need. You remember that we have had your briefs and your records for some time and are very familiar with the cases, and we just want you to go through the main parts of your case and be available to answer our questions. For those of you who have not been here, when the light goes on, when the white light goes on, you still have 2 more minutes. When the red light goes on, you should be finishing up your thoughts and your time is up. If we continue to have questions, we will nonetheless ask you, even if it's after the red light. So I'm going to call the cases now. When I call your case, please, appellant and respondent, rise and let me know how much time you are requesting. First case on the calendar is People versus Evan Zachary. Okay, submitted. Oliver 889 versus 889 Realty. Okay, we'll give you 6, 2, and 6. If you need more, if we still have questions, we'll go on. Thank you. M. Marta versus Gopal M. Submitted. Rubin versus Trustees of Columbia. Okay, 5, 3, and 5. Sampson versus Roberts.
For appellant, Principal Harris, requesting 10 minutes, 5 for one for the appellant, for the respondent, and another 5 for the intervener.
You represent both? The appellant. Okay, and who is the respondent? Five. Okay, I'll give you 5 minutes and 2 for rebuttal, and I'll give you 5 minutes. Thank you. People versus Luis Garcia Ponce. Thank you. 3, 1, and 3. Veloz versus Jiddu. Okay, submitted. Muslar versus Hall. Respondent? I'll give you 5, 2, and 5. Thank you. People versus Marcos Artiega is submitted. Bennett versus New York City Transit Authority. You don't have a cross appeal, do you? So you get 5. Okay, 5 and 2 for transit and 5 for respondent. People versus John Doe. Okay, you got it. 5, 2, and 5. Napolitano versus Bounce 21. Okay. 5, 2, and 5. Thank you. Rivercross Tenants versus Kovach. Okay, you got it. 5, 2, and 5. People versus Juan Carmona.
For appellant, 4 and 1, please. For respondent, 4.
Okay, 4, 1, and 4. Robbins versus New York City Office of Chief Medical Examiner.
For appellant, 7 and 3, Your Honor.
Is the respondent here? Okay, so do you want to still argue? Yes? Okay, we'll give you 3 minutes. If we need additional time, we will, since you won't have anybody on the other side, okay? And Paramount Painting versus Nickberger is submitted. Okay, the first case for argument is Oliver 889 versus 889 Realty. Good afternoon, counsel. You may proceed.
Good afternoon. May it please the court, Maxwell Breed of Warshaw Burstein for the appellant 889 Realty, Inc. Fundamentally, this is about commercial certainty. We have 2 parties that entered into a real estate transaction back in 2014 and closed that.
Don't you have to comply with the statutes, even if it's something that you were interested in doing? Don't you nonetheless have to, you know, make sure that the agreements you enter into are okay?
Certainly, yes, Your Honor. I can't quibble with that. But at the same time, when you have 2 parties that agree on the terms of a transaction, and fundamental to that transaction here was that Oliver 889 was never to obtain control of this residential cooperative. And by entering into that voting agreement, it induced the very transaction in which it has benefited ever since by taking possession of this real estate. And this is a voting agreement that they entered into that has a severability provision. It also has a further assurances provision. So even if the voting arrangements provided by that agreement violated BCL 501C, there are still other ways to implement the terms of that agreement. For instance, by converting to unit-based voting, which is permissible under BCL 501C. Now, if you actually look at BCL 501C, however, it doesn't provide what the respondent says that it provides. Nowhere does that provision provide that that commercial shareholders cannot enter into voting agreements or grant voting proxies like that here. Nowhere does that provision restrict this sort of transaction.
Well, how do you line up your voting agreement, which I know you entered into between you, with Section 1B of the Business Corporation Law? I mean, how does that work?
Oh, sorry, Section 1B of BCL 501C?
Yeah.
Well, I think that's the provision requiring voting parity, Your Honor.
Yeah.
Correct? So this agreement actually doesn't implicate voting parity because every share still has 1 vote. It's the manner in which those shares are to be voted that's subject to the voting agreement. Otherwise, no voting agreement would ever be valid, and you still have BCL 620, which authorizes expressly, without exception under BCL 501C, voting agreements of this type, where one shareholder...
Does BCL 620 have some temporal component to it?
Not that I'm aware of, Your Honor. And I haven't seen it in the case law either, and I don't believe that my adversary has identified any temporal component to BCL 620. He has pointed to temporal requirements for voting proxies, when they're not irrevocable, as is the case here. But again, that even if there were a temporal limitation, the remedy here would not be to strike the entire voting agreement, which goes to the heart of the deal between the parties. That would then necessitate reformation. And again, the terms of this deal can be carried out within the parameters of BCL 501C.
Here's a question, counsel.
Yes.
You do read the plain language of BCL 501c3, which requires parity among shares of the same class, and these are shares of the same class, am I right?
These are shares of the same class. Class is not implicated here because liquidation rights, distribution rights, and the like are not affected by any of the terms of this voting
agreement. Are you arguing that there should be severability pursuant to 6.1 of the voting agreement?
Severability would be required by 6.1 of the voting agreement, and that's something that the motion court overlooked. Were this court to find that the voting parity requirements of BCL 501C were in fact implicated here, then the next step would be to say, well, what of this agreement can be enforced, and how do we do that?
So you feel it should be limited just to, if we were to find that there was a problem with, I misspoke before, paragraph 1B of the voting agreement, that doesn't have to invalidate your entire voting agreement.
That's right, Your Honor. There is no world in which this entire agreement can be set aside, and the reason for that is, again, it was a material inducement for this whole real estate transaction in the first place. So if the court were to find that BCL 501C were somehow violated, in that instance, it would be incumbent upon the court to look for another way to enforce the terms. And again, the roadmap is in BCL 501C itself because of the shift to unit-based voting.
Now, can I just ask you one question to confirm something I read? Is there currently a motion pending before the motion court in Supreme Court relating to the Reformation counterclaim, your Reformation counterclaim?
Yes, there is, Your Honor, but there is no stay of the court's but for this court's appellate stay, there is no stay of the lower court's invalidation of the voting agreement. So, absent a continuation of a stay by this court, that the Reformation motion that's pending there, would be moot because we have a threat from Oliver 889 to actually retrade the entire deal here. Its principal had tried to do so back in May, and that's fundamentally that's what can't happen here. We have to have certainty like this. They got the benefit of their bargain. We ought to get the benefit of our bargain.
Let's hear from the other side, and you'll have a few minutes for rebuttal. Thank you. Good afternoon.
Good afternoon. May it please the court, Robert Bernstein of Holland and Knight for the respondent, Oliver 889. You've raised the important questions here already. There's something else that I think needs to be added. This court, there's really only one question before this court, and the question is whether the lower court erred in finding that the voting rights agreement violates applicable law, and the answer has already been given by this court on at least 2 prior occasions, and I apologize, this was not addressed in any of the briefs that were submitted, but I'd like to raise to this court, there's a decision, Madison against Striggles, it's 228 AD 2nd 170, decided by this court June 4, 1996, and determined that an offering plan which limited voting rights was not enforceable, and this court held to hold otherwise would deprive the sponsor of her rights to vote all of her shares, a result that can be accomplished only through provision in the Certificate of Incorporation, and that's BCL 612A that's cited. That cites to a prior decision of this court also, the decision of U against Linton, 68 AD 2nd 856, decided by this court March 22, 1979, and it says, respondents claim that under the business corporation law, shareholders are permitted to enter into agreements restricting or transferring rights to vote, and that the bylaws and subscription agreements in this case operate as such an agreement to disenfranchise a defaulting stockholder.
Well, I mean, assuming that, the judge below found that there was a problem with this voting agreement. So assuming that we were to agree with the judge as to the problem with paragraph 1B of the voting agreement, don't we still have to consider the severability provisions in that agreement, which seemed pretty clear to me that we could sever something that was in violation of the business corporation law, but continue along with the other provisions? And why wouldn't we consider that?
Well, there's nothing in the voting agreement that could survive that would accomplish the result that appellant is trying to urge on this court. What they're trying to do is to disenfranchise the majority of the votes. Oliver owns 2,800 shares, and they're trying to disenfranchise 2,630 of those shares, saying that they cannot vote. And that's the problem with the voting agreement. It violates law. I hear the arguments about commercial certainty. Sophisticated parties enter into agreements all the
Counsel,
time.
aren't you putting the cart before the horse? If there's a motion pending as to possible reformation, aren't your arguments better made there?
Well, we did not bring this appeal, so I'm responding to the appellant's appeal. We'd be happy to make arguments about reformation in the court below. We've addressed reformation before this court as well. The notion that there can be a reformation to the operative documents of the cooperative is outside, as we've argued in the brief, is outside the parameters of this case. If there's reformation of the agreements between the parties, that's something that perhaps the court below could address. But changing the corporation itself, changing the operative documents, the organizational documents of the corporation should not be before this court.
And we would certainly need some other parties involved in this case, wouldn't we?
That's the argument that we've made. You're correct, Your Honor. Thank you. So I think what appellant is urging, and I understand they want to represent their client zealously, and they want a victory in this case, but they're urging an upending of the law that applies to residential cooperatives. They're urging that you be able to disenfranchise shareholders from their votes. They make an argument that somehow there's a commercial transaction here. So if we let Mrs. Johnson, who lives in apartment 2A, have piano lessons and use her apartment for a commercial purpose, perhaps then we can say that she can't vote her shares anymore. There is not one single case that is cited in any of the briefs before this court where that has been upheld.
Sir, going back to a point Judge Kapnick made a few minutes ago, wouldn't invalidating paragraph 1B as in boy provide you the relief that you are seeking and also give effect to the severance clause?
Well, invalidating paragraph 1B would allow part of the relief we're seeking. What's also in this agreement are other means. There's a backup proxy mechanism which is also invalid. So anything that would disenfranchise Oliver from voting the majority of its shares would violate applicable law in the BCL. It's not just 501c3, as I mentioned, it's also 612A, and I've cited the prior decisions of this court to that effect. Whether the court below goes back to find some appropriate reformation, not the reformation urged by the appellant, is a different matter. With all due respect, that hasn't been decided yet. It's not before this court at this time, and maybe the parties will litigate that issue before Judge Leibowitz. That's entirely possible and plausible. But for the purposes of today's argument, the issue before this court, whether this voting agreement that, again, removes the essential right of a shareholder to vote their shares permanently, forever, to their successors, to their assigns, to anybody else, is simply a violation of the law, and the notion that sophisticated parties can enter into illegal contracts is simply incorrect.
So are you saying that if the court below were to say that it's going to reform the agreement or the contract between the parties and have everybody vote per unit as opposed to per share, that would also be contrary to law?
I don't think that could be accomplished, with all due respect, with a reformation of the agreements between the parties. There are other shareholders who have rights that are not pursuant to the voting agreement. That would require a change to the certificate of incorporation of the cooperative corporation itself, which is outside the scope of reformation. I think the court below would have to find a more suitable reformation of some kind.
Okay.
Thank you.
Thank you very much. Counsel, you have 2 minutes on rebuttal.
Thank you, Your Honors.
I wonder if I could just ask you one thing. You raised the issue about a stay. Now, it seems to me that I have a copy of an order that was issued by this court in September of this year, which granted you a stay pending the determination of this appeal. So it seems to me that you still have a stay that's valid until we issue the appeal, and I think you get 5 days after that or something. So it seems to me there already is a stay, and if you need a continued stay, you would have to move for that at that time. So we're not really dealing with that issue directly right now.
That's correct, Your Honor. If we were put into that position, we would have to move swiftly, and, the expectation hopefully would be that a court would grant some relief here, because I think everybody agrees, looking at the situation, that the deal was never that this commercial retail shareholder was supposed to control the co-op. This notion, by the way, of disenfranchisement, I find almost offensive, because those were never Oliver 889's shares to vote. Oliver 889 would not have those shares if it hadn't agreed to these voting arrangements. And easily, at the time
It's almost like a circular argument, but you agreed to a voting agreement that seems to violate the law. So I mean,
Right.
you worked out a deal that really was not a deal that you could work out.
Well, that's not so. The deal itself could be implemented otherwise by a shift to unit-based voting. And by the
But
way,
not the way you did it, not the way you chose to do it.
Right, that's about the means, not the ends. And that's, the means can be adjusted, and that's what reformation is for. There's no world in which Oliver 889 gets to have control of this residential co-op. It didn't bargain for that. It didn't pay for it. That would violate, it would mean that Oliver 889, either it's a mutual mistake and you have to have reformation, or Oliver 889 defrauded the co-op here. And I know that's an ugly word, but that's what this is here. This was a promise that they made, and they have to be held to it. And a shift to unit-based voting would, in fact, affect that promise.
Well, it seems to me that you have a lot that you can continue to litigate before our friend Judge Leibovitz downtown. So we will make a decision on this, and good luck there. And thank you very much, both of you.
Thank you.
Have a good afternoon. The next case for argument is Rubin versus Trustees of Columbia. Good afternoon.
Good afternoon. David Tolchin for the plaintiff appellant, Esther Rubin. Was there a dangerous condition? The stairs had no upper landing in front of a heavy, self-closing fire door.
Counsel, but the building was built in 1911, I believe, and
Correct.
the applicable building code is from 1901, and that configuration was viable under the existing and applicable building code, yes?
I assume it was. We're not saying that the building code was violated. It did say it had to be kept in a safe condition.
So then what's the standard by which you measure the, improper configuration?
The standard is reasonable care under the circumstances. The stairs had no upper landing, which is dangerous because when the door closes, if somebody is standing or walking on the ledge, the door could push that person from behind and foreseeably launch them forward, just as what happened here. In Arnold v. Egnar, the Second Department properly left the question of was this a dangerous condition to the jury. In Arnold, there was a 5 or 6 inch ledge. We have a 7-inch ledge. It's almost exactly the same, and the plaintiff was struck from behind by a door and knocked down the steps. The court said the steps led directly from the sill without a landing platform. Whether the form of construction of the door and the steps was defective was a question for the jury. As in Arnold, the jury in our case should be permitted to hear our facts and determine for itself whether this is a dangerous condition.
Sir, in Arnold, was there evidence that the staircase or stairwell complied with the applicable building code, and nevertheless, under common law negligence principles, there was an issue of fact?
I don't think the building code was mentioned in that case. I don't know one way or the other, but there was a question of fact. The one thing we know is there was no expert there. It was obvious that if you have a forceful impact from something pushing you from behind down off a precipice, that's a dangerous condition.
Counsel, on this record, this is what I understand is undisputed. It is, and if you disagree, please correct me. As my colleague pointed out, it's a 1911 building.
Yes.
No information was proffered in opposition to the defendant's motion for summary judgment, which suggested an issue of fact as to whether there was any changes since 1911 up to the date of the accident that's on this record. As far as we know, there was
We don't know.
no opposition, with the exception of your expert, making reference to the 1938 code, making reference to the need for a landing, a right-handed handrail, perhaps certain strips to avoid slipping on the three stairs. But putting all that aside, there is nothing in this record that suggests a slip and trip accident from your own client's own testimony, correct?
We do not claim that she slipped or tripped.
Good. And your own client suggests that and I use the term loosely here, the force, the projecting force that caused her to trip was her statement that she wrote in her workers' comp form, where she said, based on her perceptions at the time, that the door was slammed against her by the child she was teaching, and that caused her to propel over the three steps and land on her knee on the lobby floor. Am I correct?
Yeah, that's basically right.
Okay. So if there's no basis to suggest the violation of any building code, there's no basis to suggest that the way the original steps were configured were defective in any way, that the proximate cause of her fall was a child slamming the door behind her, then where is the issue of fact here?
Because the landing was...
I'm sorry, go on.
The landing was too small. It was a ledge that was only 7 inches long, which is smaller than anyone's foot. Now, when you push somebody off of a landing that you don't have enough even place to stand, and as you're walking forward, you get pushed from behind by a closing door. Now, she only imagined or believed that the child had pushed the door. She never saw the child push the door.
She did make that statement pretty
Sure she did, and she was wrong.
definitively in her form.
Yeah, on the form, she said, not definitively, she said, to the best of my knowledge and belief, which that's what it says at the bottom of the form. Above her signature, she says, the above is true to the best of my knowledge and belief.
Yeah, but she did say the child slammed a heavy door that hit me and propelled me into the air over the steps. I landed hard on my knee. That's her workers' comp form.
Yes, and she never testified to that, although the judge below said that she testified that that's what happened. What she testified to was, I didn't know what it was. I only imagined. I tried to piece it together in my mind. And when she wrote this, she was injured on her knee, and she was just trying to figure it out. She's not a lawyer. She's not an engineer. All she knows is she was thrust from behind, and the kid was there. But we have eyewitness testimony that says the child did not touch the door, but didn't push it, didn't add force to it. And even if the child added force to the door, it doesn't mean that the condition was safe. The egress wasn't necessarily safe because we have a very small ledge that she can't stand on as she's going out, and this was designed.
I think we got that. Let's hear from your adversary, and you'll have a few minutes on rebuttal. Thank you.
Thank you, Your Honors. Meryl Biscone, I represent the respondent here, Columbia University. There was no dangerous or defective condition here.
Well, I mean, I've looked several times at that photograph, and while, you know, it's a nice lobby, 7-inch space for somebody to stand right outside the door is a little, you know, narrow and is a little precarious. So notwithstanding what the building code said, isn't that still a question of fact as to whether that's a dangerous condition?
No, this was not a landing. This was akin to a door jamb that you're supposed to step over. It was there, the door opened inward, the handrail was there. It's presumed that you step over and onto the step. That's why it was 7 inches. We established in our motion for summary judgment that the apartment was, the staircase was safe, well-maintained, as we indicated. The plaintiff failed to rebut the showing. Again, as this court recognized, the 1911 building code was in effect. All that required was that the stairways should be provided with proper rails and kept in good repair, which it was here. We established that.
Well, counsel, does compliance with the building code establish as a matter of law your entitlement to judgment in a matter of law?
Not always, but in this case, we submit that in addition, we submitted, the plaintiff failed to rebut our prima facie showing. The plaintiff's expert failed to cite a single industry standard that was violated, no guideline, no data was provided, and there was no indication that her injuries were proximately caused by any condition that was on the premises.
Well, I have a different question. To the extent that the record indicates the plaintiff's description of the incident, she gets slammed by the door or pushed by the door or hit by the door, and she is airborne. My question is there any involvement at all with the stairs? Is there any point where we have language that says she was on the stairs and fell off the stairs, or she had one leg on the stairs and she went up? That's
No, there was...
my recollection of the record. My recollection of the record is that she was hit by the door and then went up in the air and landed.
Right, that's correct. There's no issue as to whether the staircase was defective in any manner. She wasn't on the staircase at the time of the injury. Is that your question? I'm sorry.
Yes.
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 So there's
the other three, there's 4 apartments, I believe, on the ground floor, and they all have similar stairs.
Right, all identical. And I see my light is on. Just quickly, I'd like...
The white light is 2 minutes.
Yes. The cases I'd like to... The Arnold case that the plaintiff relies on so heavily is distinguishable. First of all, there was no indication, as the court recognized, whether a building code was involved there, but that's a different factual scenario. The door there opened over the staircase. So it's a scenario where you open the door and you're faced with a staircase right there. So the court, under those circumstances, indicated that that question should go to the jury. Different here. Here, the door opened inward. The door opened inward, and she was faced with the sill and her handrail and the steps. So it's completely different from the cases as in Arnold and the other cases they relied on. Additionally...
The converse, though, is true that it opens inward but then closes outward.
Right.
Now
but it
could
doesn't
create this force that the plaintiff is alleging propelled her onto the floor.
Right, but again, no violation of any kind of building code, no violation of any industry standard, no data, no empirical data as to whether this was dangerous. And as to notice, even if this was a dangerous condition, Columbia had no notice. They didn't create the condition, they had no notice of this condition. Columbia, we established in our motion, this building was owned since 1920, and the marble steps and handrail were original construction. The plaintiff's argument that there must have been some construction because it shows no wear and tear, we submit is unsupported. I'd ask this court to take judicial notice of buildings around the city, churches, this building, even the Colosseum in Rome. Marble for centuries, hundreds of centuries, doesn't show wear and tear. So the fact that they point to the photograph in this record and it looks shiny doesn't mean that Columbia did something to it since 1920. I'd just like to end by saying sometimes people fall and it's nobody's fault. That's the case here. And we'd ask that summary judgment in favor of Columbia be affirmed.
Okay, thank you.
Thank you.
Mr. Tolchin, you have 3 minutes.
Justice Higgett, I think what you were saying was that that in both cases, the door hit the person from behind and went down the stairs. In Arnold, the door closed exactly the same way as in our case. The person was pushed from behind down the stairs, and there was no landing.
Counsel, I guess my question is, was there any connection with the stairs? And is there any opinion anywhere that but for the lack of a landing, she would have landed on a landing? Because her testimony is not that, if I recall correctly, and the record indicate that she flew in the air.
Yes. She was pushed forward, and because there was nothing beneath her, there was just air because the stairs go down. And so when she's pushed off of the precipice, she went down and landed on the steps, on the lobby floor with her knee. And had there been a landing, it would just be like any door here. There would be floor. There wouldn't be a drop-off. There wouldn't be a precipice to fall down. She was pushed forward and off the cliff.
So, sir, you heard your friend highlight how their expert, the defendant's expert, cited to the apparently applicable building code in this staircases compliance therewith, and criticizing, I mean, Mr. Robbins, I think was your expert's, his affidavit. What is the basis of his conclusion that there should have been a landing there?
Bob Dylan said, you don't need a weatherman to know which way the wind blows. It's obvious. You can't put someone walking on top of a ledge and be pushed off without a platform to stop him from falling. It's what he actually said, Mr. Robbins said, was the fact that there was no landing on the top of the stairs creates an independent dangerous condition, and it's exacerbated by the fact that there's only one handrail, which, by the way, you couldn't actually reach if you're in the door jamb because it's around the bend. But as you exit the door, the lack of the landing, this is what Mr. Robbins said on 405, as you leave, the lack of the landing limits your maneuverability. And he says today, if this were built today, it would totally be improper and dangerous.
But you do recognize that today's standards are not necessarily retroactive, right?
Well, the standard is...
You're talking about how something would be constructed today, but we're talking about something that was constructed in 1911.
Right. They weren't as enlightened back then about their building code, but as it stands now, it would be dangerous, and Mr. Robbins was explaining that based on today's standards. But it's dangerous the way it was designed.
Okay.
And there were 4 other apartments. I'm sorry, Your Honor. You asked about the 4 other apartments. There were, and each one of those people, in fact, the superintendent lived in one of them, maybe he stopped paying attention to how dangerous it was. But it's been there for a long time. Oh, and this is the one thing I did want to mention.
You got 2 minutes, not 2 minutes. You have no time, but just finish this one sentence.
1911 is when it was built. That's the same year as the Triangle Shirtwaist Factory fire. These fire closing doors were not installed then. They were installed sometime later, we don't know when, but that changed the way it was designed. And Mr. Rivera never testified as to any knowledge that he had about when these things were built.
Okay. Thank you. Thank you both. The next case for argument is Sampson versus Roberts and Lewis.
Good afternoon, Your Honors.
Good afternoon.
May it please the court, this is Fitzgerald Harris for the appellants. The main issue to be decided here by the court is whether or not the lower court improvidently exercised her discretion when she granted the respondents here is referring to Lewis and Roberts' motion to dismiss the complaint in its entirety pursuant to CPLR 3211A7. The answer is there was an abuse of discretion. Abuse of discretion because the second motion to dismiss made by Roberts and Lewis was barred. It was barred by the restrictive section of CPLR 3211E, one motion rule, because that was the second motion. There was a prior motion made in July 2019. It was denied.
But that motion was denied with leave to renew, and it didn't reach the merits.
They did not reach, it was denied with leave to renew. There are two things. Number one, it was never renewed. If you look at the motion that was filed, it was a motion for re-argument and reconsideration. Plus, that original motion was made in 2019, denied, I believe it was June 27, 2019. CPLR 2221, section D and E requires that the motion to re-argue and or renew shall be made within 30 days after receipt of the order and written notice of entry. That wasn't done. So it was way beyond the time. Plus, the court denied their motion to re-argue. The court never even granted the motion to re-argue. The court said it's denied. The lower court denied a motion. So they never renewed it. If you look at the motion, it was not a renewal motion. It was a motion to re-argue and to reconsider. The court denied that. So having denied that, what else was left for the court to do? Deny the motion, because it's the second motion. Plus.
So, counsel, your argument is that when a judge says with leave to renew, it means only, it's restricted to leave to renew, leave to file a motion to renew or motion to re-argument as opposed to filing a new motion?
What the court said, and we have to look at what the court
I'm
said.
asking you.
Yes.
Your understanding is that it's restrictive language as opposed to saying, for example, at the end of discovery, you can file a new motion based on the facts that were discerned at discovery. You would limit it to just a motion to re-argue?
What the court said, renewed, denied without prejudice to renew. Now, renewal, as we know, is governed by CPLR 2221. So they could have filed another motion within that time to renew. That wasn't filed, but they never even filed a motion to renew. That's the thing. That's what
We're saying that I think that's a little bit of a limited way to look at that statement by the court, because I think a lot of us, when we were in the trial court, might have said denied with leave to renew, which means you can make another motion. I think that it was one of the reasons it was denied was because there was no RJI. And that's a technical thing that didn't go to the merits. So they said, okay, get an RJI and then you can bring another motion. So let's assume that we're considering the merits, and do you want to address the important points that you have on that?
Your Honor, the court gave them leave to renew. They never renewed. They never said this is a motion to renew. A motion to renew has to be labeled as such. It was never a motion to renew. So we cannot assume it was a motion to renew when the respondents never said it was a motion to renew. So we cannot read into what was not in the record. They never said this is the motion to renew. The first motion was denied. That was not.
I have to say, counsel, there'd be a whole lot of very unhappy litigants if we were to view that language as narrowly as you suggest.
Your Honor, it's not narrow. It's that it was not a motion to renew. if they wanted to make it a motion to renew, they could have said that in their papers. Then I would have had a chance to argue that. I never was given a chance to argue it's a motion to renew. It was not done. So therefore, we cannot now say it was a motion to renew and the appellants were deprived of an opportunity to make that argument. We cannot do that. It's what it said. They never said it was a motion to renew. So under these circumstances, I believe they were barred by the single motion rule, and they were also barred by law of the case because back again in 2019, the court had decided those identical issues.
Okay, so we've heard your argument. Let's hear from the respondent, and we'll give you you have a few minutes for rebuttal, okay?
May I, because there are two different briefs, which I had asked
Yeah.
for 5 minutes each. They're two different briefs. The intervener also has a
Well,
brief.
I'll give you an extra minute on rebuttal, okay? So
Right.
let's hear from the other side, and then you can speak then.
Thank you.
Okay, thank you very much.
May it please the court, Mukti Patel from Fisher Broyles on behalf of the intervener respondent, MLD Mortgage, doing business as the money store. You know, I think.
So are you saying there's nobody here for Roberts and Lewis?
That's correct, Your Honor. Counsel had indicated he would be here for Roberts and Lewis, but I obviously don't represent them, so they are not here.
Okay, thank you. So you're just here for MLD. Thank you.
Yes, Your Honor. So I will try to limit my arguments just to MLD, but there's a lot of overlap between the two. First, to address the single motion argument, I don't believe, and it's not raised in our briefs, but I don't believe that argument was actually raised before the trial court in response to the motion to dismiss filed by the respondents. And even if it was, MLD was certainly not a party to the case when that original pro se motion to dismiss was filed. And so that motion cannot preclude MLD from filing its own motion to dismiss, which is based on the same grounds as the motion to dismiss by the other respondents. And in fact, MLD's motion was only denied as moot because the other motion was granted. And so, you know, procedurally, there would be an independent basis for the trial court to dismiss the complaint, vacate the notice of lis pensens based on the motion to dismiss filed by my client, MLD. Moving on to the law of the case doctrine, I'll be very brief. The law of the case doctrine here would not be applicable. The order, and that is referred to in reliance on the order law of the case doctrine, is the February 13th, 2020 order. That was about an order to show cause, dealing exclusively with whether the housing court eviction action should be transferred to the trial court. It did not address a motion to dismiss or a standard for a motion to dismiss, and thus, and MLD was not a party when the pleadings and the briefings were submitted for that order to show cause. MLD didn't become a party to this action until January 6th of 2020, and again, was not part of the case when the order to show cause was briefed. Moving on to the merits, I mean, I think that there isn't really a dispute because all of the facts that were relied on in support of dismissing the complaint and vacating the notice of lis pendens were taken from the verified complaint of the appellants. This was a scheme to defraud the mortgage company and to defraud and get a discount on having to pay back the mortgage. And whatever agreement that appellants rely on is based solely on an oral agreement for the sale of property, which is barred by the statute of frauds. The only exception that they can claim to that is the imposition of constructive trust. It doesn't apply here. There's no relationship here there's no confidential relationship here that it would apply to. Even by the actual allegations in the verified complaint, this was at best, and it's in dispute, but it would have been a 1 to 2 year friendship, not a 20-year-long relationship with financial interactions between the parties and
So even if the complaint alleges that the parties developed a very close, loving, and trusting relationship, that has to be for more than 2 years? That's not good enough?
Well, Your Honor, the case law, and we cited the case in our papers, May Yun Chen versus May Wan Kao, when when a constructive trust was imposed, that relationship was a 20-year relationship where there was no familial relationship, but they had been in business together and had financial dealings with each other over a course of 20 years. We simply don't have that here, even taking the allegations of the verified complaint at face value.
Well, oftentimes whether there's a confidential relationship is sort of a sui generis inquiry, right? And those type of inquiries normally don't lend themselves to a 3211 pleadings motion. So is there some other basis on which you sought dismissal of the constructive trust claim?
Yes, Your Honor. There is also the issue of a constructive trust is equitable relief. And we submit that based on the allegations in the verified complaint, there was a fraud being committed here, rendering the appellants with unclean hands, whereby they cannot be granted equitable relief in the form of a constructive trust. And, very briefly, once the verified complaint was dismissed, there was no dispute over the property, so the notice of lis pendens was properly dismissed. With respect to MLD, I only ask that if the court does reverse for some reason and remand back to the trial court, that MLD be allowed the opportunity to pursue the alternate relief of equitable subrogation that it asserted in its motion to dismiss that was not decided on by the trial court.
Because it was moot once
Yes.
the other, okay.
Yes, Your Honor.
Any other questions? Okay, thank you very much.
Thank you, Your Honor.
Counsel, we'll give you a few minutes on rebuttal to address whatever you would like to address.
Thank you, Your Honor, because I never addressed MLD's
All right.
motion, so I'm going to go to MLD's motion.
Fine.
Every single issue MLD raised on this appeal is moot. MLD's motion to dismiss was denied as moot, and they never appealed it. So they are now bound by the decision denying their motion as moot. That is the law of the case. It is moot. So any issue that comes here by MLD is likewise moot. Secondly, MLD got intervener status before, at least a month before the motion was decided. They are bound by the decision that was rendered back in 2020, June 13th and entered in June 19, 2020. The identical issues that were raised in their motion to dismiss were raised before the court. And the law of the case, that is a doctrine. It does not specify whether it's a 3211A or 3212A motion. It says issue. Once it has been decided, you had against you had a full and fair opportunity, and you never did anything. You never appealed. It's the law of the case. So therefore, they are bound. The court, in that June 13th decision, addressed constructive trust. They addressed fraud. They addressed statute of fraud. Everything was addressed there, and it was never appealed, either by MLD, who had a chance to appeal, because they were now interveners at least a month and like 10 days prior to this decision. So they never did that. So now you are bound. So this court now coming back and ignoring their own decision, the own law of the case, and dismissing it based on the same issues. And that is what the law of the case refers to, issues. It doesn't say 3211. Another thing, MLD is talking about establishing. 3211A is not about establishing, it's about allegations. And this court can look at the allegations. Look no further than the 13th, the June 13th, 2020. It's about if you sufficiently allege. It's an all common law doctrine, the mirror. It's short, falls short of what it's supposed to be. So therefore, it's not establishing a constructive trust, it's alleging. So if you're going to an issue to say, well, they did not establish, that's not the standard. As long as it's sufficiently alleged, and this court has an obligation to accept every single allegation as true. It's just the allegation. Once it's accepted as true, you meet the standard for 3211A7. So what they're conflating is a 3212 summary judgment that has to be established, no questions of disputed facts, etc. That's not the standard here. That's why the court abused her discretion. Every single allegation, every single cause of actions were adequately pled. And that was not the question. It was already proven, the court already agreed. So for the court now to go back and ignore this What I believe is that someone just did not see this old decision and just went ahead and made an error. And that's why this court should reverse that lower court decision. Thank you.
Okay, thank you. Thank you both. We will certainly look at this carefully. Have a good afternoon. The next case for oral argument is People versus Garcia Ponce. Good afternoon.
Good afternoon. May it please the court, Svetlana Kornfein for Appellant Luis Garcia Ponce. The people failed to prove the physical injury component of risk factor 1 by clear and convincing evidence for each of the two relevant complainants. The people's case below is based entirely on the grand jury minutes. There was no objective correlation presented to the court, no photographs of the injuries, and no medical records. The court's...
Well, there's not a requirement.
No, there's no
there that
requirement.
those be
There's no
produced.
requirement, but it undermines the people's argument that these met the clear and convincing standard for physical injury.
Your argument, counsel, is that the grand jury testimony of the various victims as to the injuries that they sustained, that's not dispositive?
Well, it has to be clear and convincing, and the court ruled that there were 3 that they proved out of the 5. However, one of them was the victim of a robbery. There was no sexual crime, and the people are not disputing that that was an error. So there are only 2.
If it's proven that one of them sustained serious physical, if it is shown at the hearing that one of the complainants, one of the victims, sustained physical injury, wouldn't that be enough?
Yes, it would be enough, but they, for the first...
So you have complainants testifying in the grand jury to sustaining pain and bruising that lasted for more than a week. One even went back to see a doctor and was treated for her injuries by a doctor. One sustained scratches and bled under the eye due to a laceration, scrapes to her knee and under the chin, and also received medical attention at a hospital. Wouldn't that be sufficient?
I don't believe that any of them testified that they received medical attention at the hospital.
Is that dispositive, counsel?
No, it's not dispositive.
It has to be more than a petty, what is it? Petty slap, shove, kick, and the like.
Right,
but so isn't this more than a petty slap, shove, or a kick, and the like?
Well, the two complainants at issue are the first and the fifth.
I believe that the 5th did testify that she went to the hospital and had to see a doctor for her injuries, so she did testify.
I thought that she testified she was going to see the doctor the next day.
She said she went to the hospital and had to see a doctor for the injuries.
Then I stand corrected, but even so, there were no records. So we have no idea really of the severity objectively. We just have the first complainant was bruised, and the last one had cuts and scrapes on her knees and face, and we argue that that did not meet the clear and convincing standard.
Okay, let's hear from your adversary, and you'll have a moment on rebuttal. Thank you.
Good afternoon, Your Honors. Connor Burns for the people, and may it please the court. Defendant's guilty plea forecloses his SORA claim here, and in any event, the grand jury testimony that was presented at the SORA hearing did prove by clear and convincing evidence that both victims won and... Yeah.
Slow down.
I apologize.
Please.
Sure. And the grand jury testimony did prove by clear and convincing evidence that both victims 1 and 5 did sustain a physical injury. As a part of his plea, the defendant did plead guilty to both burglary in the first degree and robbery in the second degree. Both are as an element, have physical injury. And not only that, during his allocution, he did admit that he caused physical injury to both victim 1 and 5. Now, setting aside the guilty plea, as the panel was discussing, the injuries were certainly severe enough with both victim 1 and 5 to rise to the level by clear and convincing evidence of a physical injury. The judge at the SOAR hearing even noted that he had never seen bruising so extensive when he noted on victim 1's injuries. She had suffered extensive bruising to her head, her back, her arm, her chest, her buttocks, and this was the result of a violent attack. The defendant forced her to the ground. He slammed her head multiple times against the stairwell and then physically touched her body. And victim 5 as well was a fairly violent attack, and she did sustain serious injuries. She bled from her knees, her face. She sustained a laceration under her eye about 1 inch to 1.5 inches in length, and she did go to the hospital either that night or the next day to receive medical treatment. And I believe for all those reasons, the SOAR court was correct to assess the 15 points for physical injury, and that should not be disturbed here on appeal. And if there are no questions, I'll ask that you affirm.
Do we afford the SOAR court's determination as to the scoring on a factor any deference as opposed to an upward or downward departure where we clearly do?
I'm sorry, could you repeat that, Your Honor?
Do we afford the SOAR court any discretion with respect to the allocation of points under a particular factor? We certainly have to give a SOAR court discretion when it makes an upward or downward departure, but what about the scoring of the individual factors?
I'm not sure any deference this court would give, but I'm sure, I would argue that that court would certainly be in the best position to make that determination. I mean, they heard all the evidence, and they had both counsel there making the arguments at the SOAR hearing, so I would certainly argue that they would have be in the best position to make the determination on the points. Thank you.
Thank you.
I just have 2 brief points. Sure. Counsel said that the court saw the injuries. The court was using, I see this extensive bruising figuratively, not literally, because these incidents happened in some cases months before the SOAR hearing, so he meant I see figuratively. The other thing, they mentioned the plea minutes. That argument is precluded because of LaFontaine. It's an argument they did not raise below. They did not present the plea minutes to the court below. And this case, 2 weeks ago in People v. Bonilla, and I would just like to read from Bonilla because that's exactly my position. The people's current arguments on appeal are precluded by People LaFontaine because the suppression court, here reads SOAR court, did not rule upon these issues, and this court may not affirm on those alternative grounds. So your decision should be limited to what the SOAR court had before it, and that was the grand jury minutes. Thank you.
Okay, thank you. Thank you both. The next case for oral argument is Musler versus Hall.
Good afternoon, Your Honors. Paul Scatromer on behalf of the plaintiff appellant. The plaintiff appellant is asking you to reverse Supreme Court's denial of plaintiff's motion for summary judgment dismissing defendant's affirmative defense of plaintiff's culpable conduct. We are asking you to reverse Supreme Court's granting of defendant's global and GDM's motion for summary judgment pursuant to the Graves Amendment, and we are asking you to reverse Supreme Court's denial of plaintiff's cross motion retaining venue in New York County.
Well, first, as to your first issue, you had your client, the plaintiff, was the passenger in this pickup truck, correct?
Yes, Your Honor.
And there's never been anybody that's raised a question as to whether or not he was the passenger or the driver, is there?
Correct, Your Honor.
So was there anything in those papers that actually claimed that your client was culpable for this accident?
No, No, Your Honor, most of defendant's argument was that we don't know what my car's host driver did to avoid the accident.
But that's not your client.
Correct, Your Honor.
So I'm not really sure there was anything that I saw that was really against that. So why don't you go on to the Graves Amendment issue?
Thank you. Your Honor, Vehicle and Traffic Law, Section 388, makes the owner of a vehicle responsible for the negligence of a driver driving the vehicle with its permission. Defendants seem to conflate who has the burden of proof in a Graves Amendment motion. Defendants Global and GDM
I
were
don't
seeking
understand,
to be
counsel.
relieved.
I understand, one company owned the truck, one company leased the truck, but there was no connection with the actual operation of the truck, the selection of the truck. My understanding from a reading of the record is that they never even saw the truck. So why would they have control over the actions of the driver?
We're not alleging, Your Honor, that GDM or Mobile had control over the driver. We're alleging
But you're
that...
citing the VTL as opposed to the Graves Amendment, which says that states can't impose vicarious liability on owners, lessors, unless there was negligence shown by the owner, lessors.
That's correct, Your Honor, but GDM and Global still have to show that the vehicle was leased. And they lease it. They've
Well,
never shown that.
Didn't they give you copies of the two leases, the lease from the owner and the lease from the, like the sort of the intermediary person who actually leased the vehicle and to Asplund and was collecting the money and giving it to the owner?
That's plaintiff's argument, Your Honor. They never included in the motion
But
papers.
I thought I did see the leases in the record, no? Did I not? I mean, the leases were there, so they...
No, Your Honor, they're not in evidentiary form.
Isn't it in the record on page 89 and 90?
They're not in evidentiary form, Your Honor. They're pieces of paper. No one laid a business record foundation for it. No one certified it. The two witnesses from Global and GDM never said they were making this of their own personal knowledge. And as a matter of fact, the affidavit of GDM in the document that they do include specifically says this is controlled by a master lease, which they never provided.
Sir, before the trial court, the motion court, did you object to the admissibility of these purported leases on the ground that they weren't business records under 4518?
Exactly, Your Honor. You'll find that in my opposition papers in the record. And then the final relief that I've requested of the court is that if it's found that Global and GDM are appropriate defendants and that they fail to move and succeed, that venue should be kept in New York County. If this court finds that GDM and Global did prove their case and they should be dismissed, I would ask that venue still be, plaintiff's cross motion be granted and venue still kept in New York in the interest of justice.
All right, I'll let you, you can speak about that afterwards on rebuttal, okay? Thank you very much.
May it please the court, Wayne Graver on behalf of defendants, respondents. I believe that the court has correctly identified the crux of these appeals, which is the application of the Graves Amendment.
So what about counsel's argument that you did not put these leases in admissible form and therefore, you know, you're not entitled to summary judgment?
Just as Justice Klein's evaluated the evidence, so should the evidence be evaluated at this level. And while there were peripheral objections to the items that were submitted in support of the Graves Amendment, the evidence is still overwhelming. The fact that Global rented this truck to GDM, then to Asplund, the rental payments were made and received, the rental agreement between Global and GDM was produced. GDM rented the truck from June 24, 2016 to Asplund until the day of the accident, and GDM never possessed or controlled the vehicle, and the rental agreement between GDM and Asplund was also produced. The bottom line is that the vehicle was in the possession of the transferee, the lease payments were made by Asplund, the rental agreements were provided and were enforced, and the most important evidence in this case with respect to that is the performance of the lease. That evidence is overwhelming. For 1 year and 9 months, the lease was actually performed in every respect, notwithstanding any questions about not using the magic words in the affidavit of personal knowledge or having a cross out or a typo. I submit that the evidence at this level and at the trial level was adequate, if not overwhelming, to establish that GDM and Global were in the business of leasing vehicles commercially.
Well, sir, is it your position that you did sufficiently lay a business records foundation under CPLR 4518 for the relevant lease agreements?
Yes, yes, sir.
Okay. And assuming we disagreed with that, is it your position that there is other independent evidence that would otherwise satisfy your prima facie burden?
The evidence in this case is that, and sticking now with the issue of performing as a lessor of the property, I submit that the independent evidence is the fact that the parties, all 3 parties to this transaction, performed for 1 year and 9 months under the terms of the agreement. A lot of times contracts may be vague, but the court will recognize by the performance of the parties the continuation and performance of the contract. The next issue is whether or not I see I'm running out of time here.
Yes, as I said, when the white light goes on, you still have 2 minutes.
Okay. The next issue is the argument by the plaintiff that there was an absence of evidence that there was negligent maintenance of the truck. The fact that the truck was used for 1 year and 9 months, any alleged negligent maintenance that may have occurred on the day of the accident could not reasonably be attributed to the 2 parties who leased it 1 year and 9 months before.
But wasn't there an admission in the police report by the driver of the leased truck who admitted to making an illegal U-turn that ultimately caused this accident?
And Your Honor anticipated my very next point, which was the undisputed facts, as set forth by the plaintiff, are that there was an intentional act by our driver in trying to make an illegal U-turn, crossing a grassy median for that purpose, and then in the process, striking.
Sir, not your driver, Asplund's driver.
Asplund's driver. But we represent both parties. We represent the lessors and Asplund and Hall.
So there's no issue with any maintenance issue with the truck then?
There is not. So the bottom line is that there could not be any negligence attributed back to the lessor of the truck for what happened at the time of the accident.
And do you disagree with me that there really can't be any culpable conduct placed on the plaintiff in this case? I mean, he was the passenger.
Your Honor, that's an issue that I think the court could easily find in favor of the plaintiffs on. The only issue that we raised is 99 times out of 100, the passenger plaintiff is not a culpable party.
Of course not.
But there have not been any depositions taken in this case. And while there may be a deposition that is taken of the occupant, the other occupants of that vehicle, that may show something, it probably won't happen. My only point, Judge, is without that evidence, the process should continue. I'll submit to the court right now that if we take depositions and we don't find any evidence that the plaintiff did anything wrong here, I'll be the first one to sign a stipulation to remove that defense and agree with plaintiff's counsel, and it won't be an issue going forward.
So the defendant also has not been deposed?
No one has been deposed in this case, neither the plaintiff nor any of the passengers or occupants of the other vehicle.
Okay.
Okay. Any other questions for this counsel? Okay, we'll hear from the plaintiff on rebuttal.
Your Honors, with all due respect to my learned colleague, his statements that the truck was not maintained by Global or GDM, or that the truck was out of Global's possession for 613 days, is nowhere to be found in the record. There is no foundation to support those statements. And that's
Has
the
there
whole
been any discovery? I mean, counsel has indicated there's been no depositions. Has there been any other discovery?
Surely. I provided counsel responses to all of their discovery demands. I provided counsel with every medical record I had in my possession. The only thing that hasn't been provided is any document exchange from defendants and their reluctance to go forward with depositions, Your Honor.
So, sir, have you received any maintenance records related to the vehicle?
No responses whatsoever from defense counsel.
Was there any wait, there was no testimony yet. All right. Am I right?
My apology, Your Honor, I didn't hear you.
The only issue as far as the facts are concerned that we have before us is the U-turn. The U-turn made on the northern state by the truck driver employed by Appellate, right? There's no allegation of a defective truck, of a defect in the
I
truck.
made an allegation in my papers, Your Honor, of failure to maintain the truck.
Yeah, but that would be up to Appellate, who leased the vehicle for almost, what did you say, a year and 613 days, as you pointed out. So your case still let's accept for purposes of discussion.
Yes.
That the Graves Amendment applied and GDM and Global are out of the picture. You still have a case against Appellate, correct?
That's correct, Your
You
Honor.
still have a case against their driver, correct?
That's correct, Your Honor.
And in that process, you could still get discovery with respect to the maintenance of the vehicle, notwithstanding the omission of the driver that he intentionally made an illegal U-turn.
That's absolutely correct, Your Honor. The only thing I would state is that it was Global and GDM's obligation. It was their burden of proof when they made the motion to get out of this case that they had to come forward and address that issue, and they totally failed to provide any evidence on it.
Sir,
Thank you,
if
Your
I
Honor.
understood your friend correctly, and you can signal if I'm wrong, that if we assumed that there wasn't a sufficient business records foundation for the leases, nevertheless, the course of performance between the parties over an extended period of time would demonstrate the requisite elements for the Graves Amendment defense. How do you respond to that?
Trying to address Your Honor's question, my belief is when they bring a motion for summary judgment, they have the obligation to prove their case. Only once they make a prima facie case does the burden shift to plaintiff to come forward and rebut that.
But I guess, I think what Justice Higgett was asking, if I'm not incorrect, is assuming you're correct and there was no business record foundation laid appropriately in these motion papers, can the defendant nonetheless rely upon the fact that there was a course of performance over a year and a half that showed that, in fact, there was this leasing arrangement as they allege?
Yes, Your Honor, if that was in the record, but it's not.
You're saying there's no proof of a course of performance? You're saying that's...
Absolutely none.
So you disregard the affidavits of the principals of Global and GDM?
The affidavits from Global and GDM...
You disregard them. They have no meaning to you. I know you claim they don't have personal knowledge, but they do. They have personal knowledge and are familiar with their business arrangements of how they operated, how the Global truck went to GDM and how GDM went and then ultimately leased it to Appellate, and they discussed the whole payment arrangement here. Right. So you disregard all that? You don't think that's enough?
I don't disregard that, Your Honor. All I'm stating is that Global and GDMs are major corporations. Those affidavits weren't made on personal knowledge. If they were, they could have stated it. But I mean, this was really made on business records, and they don't include them, and certainly don't include them in proper form.
Okay.
Thank you, Your Honor.
Thank you. Thank you both. Have a nice day. Next case for argument is Bennett versus the Transit Authority.
May it please the court, Tim O'Shaughnessy from MTA Law Department for Transit and the bus driver. It's not until page 8 of her brief that the plaintiff dares even mention the video. And more importantly, she never mentions the relevant dispositive facts that are revealed by the video. Those are that the bus driver did look in the left-hand side viewing mirror.
How can we see, we've all looked at the videos, and I know there was an awful lot of different cameras and views that we could see on those videos, but could we actually see that the bus driver was looking in his left?
Yes, yes, yes. The camera that was pointing on him shows that he looked. But more importantly, the view out the front windshield shows that the lane that the bus was in, lane 1,
Right.
was completely clear. So the bus was going to go straight. It was not going to try to merge into lane 2. It also shows that lane 2 was completely clear.
Lane 2, you're talking about the lane to his left.
Yes, that Mr. Druitt was driving in. Mr. Druitt had absolutely no reason not to go straight, which is to say, and the question here is not Mr. Druitt, but the bus driver. It was not negligent for the bus driver to fail to foresee that Mr. Druitt would do what he did. And he had a tiny amount of time to decide what to do when Mr. Druitt did what he
So
did.
I know that Judge Adams had this case, and she said, well, the motion is denied because there's been no discovery, and you can renew your motion after there's discovery. So your client, or at least your driver, gave in an affidavit but never appeared for a deposition.
That's correct. In the papers below and in her brief in this court, plaintiff could not even hypothecate one possible fact that discovery could have revealed at all, much less a fact that would have required denial of the motion in the face of the video.
Sir, on your viewing of the tape, what was the maximum amount of time the driver had to react to the situation he was confronted with?
I can't say, but I would say from just looking at the tape, it was virtually instantaneous.
Okay, we'll hear from your adversary, and you'll have a couple minutes if you would like to respond. Thank you.
Good afternoon, Your Honors, and may it please the court, Stephen Grossman for plaintiff respondent. This case, as we already talked about, is on video. There was approximately 1 to 2 seconds wherein the defendant bus driver could have stopped the vehicle before the other vehicle cut into the...
Well, the thing was, he did stop the vehicle. That was the problem. That's why the lady fell.
There was no honking horns, and while that break was sudden and violent, there was enough time for the bus driver to look over their left shoulder to see if there was oncoming traffic.
So we've all seen the videotape, and it's actually startling to see the trajectory of events that took place. It appears that, as everyone has said, both lanes were clear, and out of the blue comes not a car that moves over, but a car, out of the blue comes the car at an angle, which seemed to predict a very, very, very imminent collision.
Yes, Your Honor. The lanes in front of them, in front of the bus driver. Yes, Your Honor. The lanes.
What in front of them?
The lane, the bus lane, and the middle lane in front of the defendant bus driver were clear, but the lanes that were in back of the bus driver and the lane that the co-defendant were traveling at the time of the accident.
We have pictures about the lanes behind the vehicles? I never heard
I'm
such a
sorry,
thing.
I would just characterize it as the middle lane and the bus lane. The middle lane facing forward of the bus was clear. The bus lane facing forward from the bus was clear. But the lane from the back, the bus had just crossed over the intersection and had been had been on the opposing side of the intersection, on the opposing side of the street for approximately a second to a second and a half before the other driver continued to cut over. I would just argue that based on the violence of the fall, the suddenness of the stop, that the defendant bus driver could have taken steps to make sure that the stop was safer,
How?
more reasonable.
That's what I want to know, how? Because this happened so fast.
As you're going over the intersection to make sure that there was no other drivers coming from the left-hand side.
There was nothing. Everything was clear ahead.
That bus is also over 30 feet long, that it would be who of the driver to be able to
The
tackle.
council, the
So
mechanics.
the only way that this thing could have been avoided if he didn't move at all.
If the bus driver didn't move at all,
Exactly, because as soon as he started moving, the other vehicle cut him off.
the bus driver could have also taken evasive maneuvers, honked their horns.
Where was he going to go? Left? If he goes left, he hits the car. If he goes right, he probably hits a pedestrian. So where's he going to go?
I think there's a
I
car
would
there,
argue that
too.
if he goes right, he would stay in the bus lane, but respectfully.
I
So
saw,
then stop and don't move. That's all he could do.
Yes, stop and don't move with a safe distance. If you notice on the camera, the G-force goes from 0 to over 1.1 Gs. That's quite an acceleration and deceleration from the time that the bus was moving down to
There
nothing.
was no claim that the bus accelerated too quickly. The bus stopped. We surmised that the car that was in the space that arguably the bus blocked came around. And then with the lane clear, there was no reason, let me say it this way, sir. Where on this record, based on the videotape, do you suggest that the bus driver should have foreseen with clear lanes, a clear lane on the left side, that vehicle, Mr. Druitt's vehicle, would suddenly cut in front of him so that he should honk, do all the evasive maneuvers you claim could be done in a nanosecond?
I would argue that it's more like a second to a second and a half, that if the defendant's driver's testimony indicated that they had seen or didn't see the other driver, there would have been a way that the defendant driver of the bus would have just stopped the bus in any ordinary New York traffic kind of condition where the driver would cut over into a bus lane.
Putting aside any other maneuvers or actions the driver could have taken, just looking at what he did, would you say that what he did was a reasonable response to the emergency situation he was presented with? Not necessarily the best, but was it a reasonable response to that emergency?
I would point that the force of the deceleration and from moving to stopped was so great that it caused an unsafe and negligent condition that could have been avoided had the driver stopped gradually, turned the car to the right, or paid attention to the other vehicle that was coming from its behind. We have no deposition testimony of the defendant to indicate that they even saw the other vehicle coming from the middle lane, and we leave it at that.
Okay, thank you.
Thank you.
Counsel, do you want to take any time for rebuttal? Any questions for transit? I think not. Okay, thank you very much, and have a nice afternoon, both of you. The next case for argument is People versus John Doe.
You need your mask?
The new dilemma, what do you do with someone else's mask?
May it please the court, Shayna Watrous on behalf of Mr. John Doe. So I'd like to address the lesser included count. The standard is whether there was a reasonable view of the evidence when viewed in the light most favorable to the defense that Mr. Doe did not cause the complainant physical injury. So we know that Mr. Doe's actions caused some bruising, redness, and 2 small scratches. But the jury was entitled to reject the idea that any of her pre-existing injuries, her neck pain and her back pain, were caused by Mr. Doe.
Well, they were certainly free to reject it. They were also free to accept the testimony that she had gone to see, I guess, was it a chiropractor?
Yes.
Several months before, she had a problem. She went to see him again, everything was fine, and she left. And this was much more severe in a different part of her back. And she had, as they said, had much more severe pain. She was very roughed up. Witnesses said that. She was banged back and forth. She had abrasions and cuts. So yes, they were free to reject it, but they were free to accept it.
And if they were free to reject it, again, viewing the evidence in the light most favorable to the defense, you needed to give the jury the opportunity to consider that all that was caused by Mr. Doe was that redness and bruising and the scratches. Given that it could have been very difficult for the jury to disentangle the evidence of the past pre-existing injuries that she had and the current ones. If you just look at the notes from the chiropractor says C-spine subluxations and myospasms. That's in May. And then in September, C-spine subluxations and myospasms. Same thing. He writes the same degree of pain, 6 out of 10, and then he only adds bruising, redness, and abrasions.
But he testified that the pain was 9 out of 10 instead of 6 out of 10, that was a typo on his part.
He said that
the pain was much greater when she went back to him in September.
He said that he believed that was a typo. I think it was up to the jury as fact finder to determine.
And it was also, I thought there was also a testimony that her problem was with her neck and her shoulder, and those pains had resolved several months before the accident, that she had not previously had back pain in the area in which she had this back pain, and it was unlikely that this pain would have reappeared on its own for no reason, especially after this kind of roughing up, so that there was a connection.
So 2 things. One, initially the pain was spontaneous, and then also the chiropractor said that he thought that actually it was probably the same areas that she had had it in before. So again, this should have been a question for the jury as fact finder. They should have had the opportunity to, if they sort of threw up their hands and said, we really can't disentangle the previous injuries from the current ones in terms of the pre-existing injuries, the neck and back pain, and they should have been able to consider whether just the bruise, redness, and 2 scratches were enough to...
Did the chiropractor also testify that she was in so much pain that he didn't even want to touch her? He didn't even want to do any manipulation or anything of that sort because he was afraid that he would make things worse for her.
He didn't do any manipulations, that's right.
Right.
We also know that in May, she had said that her pain was getting worse. Who knows what could have come up after,
but after
she had
June, she didn't see him again. She stopped seeing him in June because she was okay by then.
She did.
She saw him again in September.
She felt that her pain was manageable in June, and then several months later, again, we know that her pain can come on spontaneously. And again, even if this court believes that this was caused by Mr. Doe, still we need to view the evidence in the light most favorable to defense and just...
So, counsel, what about the victim's testimony that she suffered substantial pain in her left arm? She had trouble sleeping for about a month. It took at least a month for the bruise on her arm to fade, and then she had pain. It took 2 or 3 months for the pain in her body to heal, to improve. Is that to be discarded?
So again, we're just saying that the jury should have been able to consider this, that there was a reasonable view that this was her pre-existing pain, and that the jury could have...
If a person regularly sees a chiropractor and then ceases to see that chiropractor because the person's ailments have improved, the fact that there is a significant hiatus or any hiatus between that and the time of the assault, that's discarded?
It's not that that should be discarded, but again, it should have been up to the jury to decide whether that was, new pain that was caused by Mr. Doe or whether it was new pain that was caused spontaneously the way that the prior pain had been caused. I'll reserve for rebuttal. Thank you.
Okay, we'll hear from the people, and you'll have a couple of minutes in rebuttal.
Good afternoon, and may it please the court, Catherine Murata for the people. There is no reasonable view that the victim did not suffer physical injury as a result of this attempted second-degree robbery. Just to address the injury that defendant claims was pre-existing, Dr. Conti, the chiropractor, testified at trial that the pain that the victim sustained or felt in September, the day after the incident, was much more severe than the pain she felt at the May 2018 visit. She rated her pain a 9 out of 10 in September, where she rated her pain a 6 out of 10 back in May. She also the victim also credited her pain in May due to her planning for her wedding and sitting in her chair at the office for long days. Furthermore, the victim credibly testified that as a result of defendant's actions, she suffered bruises, abrasions, redness, which is alone sufficient to constitute physical injury, even though here there is also the pain in the upper back, neck, and shoulders. The victim, in addition to the victim's credible testimony, there's objective corroboration from the photographs that she took the night of the incident.
Wasn't there also a witness who saw the defendant bang her against the turnstile bars several times, trying to grab her backpack off?
Yes, that's
to support her claim that she had bruises on her back from that and her buttocks?
Yes, that's correct. At the subway turnstiles, a witness saw defendant jerking Ms. Paisano's body back and forth against the metal turnstiles. The witness claimed that defendant was roughing the victim up. After the incident, while in the subway station, officers observed victim very shaken up, having slurred speech, very stressed out. Also, she was wearing a long sleeve shirt, the victim, so when she returned home that night, when the adrenaline wore off, she discovered that she had the bruises, the cuts, the abrasions that night. The next day, she reported her injuries to the DA's office and sought attention from the chiropractor.
And even though, as we said in the other case, it's not necessary, the evidence did include photographs of this victim's injuries. Is that correct?
Yes, that night when she returned home, she photographed her injuries, which was the 3-inch bruise on her left arm, the redness on her back and torso, the cuts on her fingers. So that was objective corroboration of her subjective description of how she felt. Also, Dr. Conti, her chiropractor, corroborated her pain and injuries in his records of her visit, and also he testified at trial as well, corroborating that she had sustained those bruises, abrasions, and redness, and also he confirmed that the injuries and pain that she felt in September were more severe than what she felt in May. Just to note also that her pain that she felt in May had been resolved by June 2018, and she was feeling much better, so that undermining the claim that that injury was pre-existing.
So her claim that this was a spontaneous problem was speculative, no?
Yes, that injury had been resolved. It's a wholly separate injury than the one that she sustained in September, which was, she was being jerked back and forth against the metal turnstile, and she rated her pain as a 9 out of 10. She sustained a lot of pain. And just note the threshold for physical injury is low. It's physical impairment of physical condition and substantial pain, and I think that was satisfied here. And there was no reasonable view that the victim did not suffer a physical injury. I can address defendant's sentence if the court would like, otherwise.
You have 44 seconds if you want to. Go ahead.
Sure, here there were a variety of factors that support defendant's sentence. He committed 2 crimes within a span of 10 minutes that day. The first was at 50 Rockefeller Plaza. The second one was at the subway station. They both were violent crimes. He approached both victims who were unsuspecting from behind and tugged violently and jerked their bags from them. In addition, he has an extensive criminal history of similar crimes, although not in New York, but they're in DC, Virginia, and Maryland. Attempted second-degree theft, grand larceny, a robbery in 2011, whose facts are similar to the facts here. And also I'll just finish up, but just that he has made no efforts at rehabilitation or has shown no remorse for this crime. So taking those factors all into account, his sentence was fair and appropriate. Thank you.
Thank you. Counsel, you have 2 minutes.
So I would just reiterate that this is not about a sufficiency standard. This is about the much lower standard that's applied when you're just asking for a lesser included count. That's an intentionally low standard. As long as there's any reasonable view of the evidence that the jury could have rejected the fact that these were new injuries, these injuries that were virtually identical to the prior injuries, these injuries that came on spontaneously from sitting in her desk. She still has that job. She's still sitting in the desk. The jury was entitled to reject that if they had chosen, if they had had the opportunity to consider this lesser included count. And for that reason, viewing the evidence light most favorable to the defense, this should be reversed for a new trial. I can briefly address the excessive sentence as well. Mr. Doe has completed some college and had secured a job at a seafood restaurant in Manhattan just before this. He asked at sentencing not for his freedom. He understood that there needed to be accountability for what he had done, but rather that he have resources in the community and monitoring in the community so that he could prove that he could get on the right track with his life and his mental health. So we would just ask for a reduction in the interest of justice. Thank you.
Okay. Thank you. Thank you both. The next case is Napolitano versus Bounce 21.
Good afternoon and Happy New Year.
Good afternoon.
My name is Mark Alonso of Alonso, Andel, and Thatcher, and I'm here arguing on behalf of the defendants. Before I start, let me just point out, I am not suggesting that the complaint should be struck completely. I believe it fails to state a claim for two important points, but obviously everyone has the right, even if it's unsupportable, to assert a claim on an oral agreement, even one from 2011. The problem is, in this case, is with two aspects of it. The first of which is entitlement to a percentage of a liquor licensed establishment. And the second point is a right of first refusal, an option, if you will, in perpetuity. Before we go on to that, let me just point out, on 21st Street, there was a bar, and it was owned by New Lounge, 4324. That's one of the defendants. The owner was having problems, it wasn't doing well, and another company, Bounce 21, LLC, came in to buy out most of his percentage, all but ultimately 14%. But that company, Bounce 21, was itself an LLC, and it has as its members Eli Benvenisti and 25 or so, in the 25%, another group of members who had varying tiny percentages. Thus, Bounce 21 is merely the majority member of another entity. Apparently in 2011, according to paragraph 21 of the complaint, I'll quote the exact sentence, in or around March 2011, Plaintiff Napolitano and defendants Benny Silman and Yossi Benvenisti, not in the quote, that's the son of the majority owner, entered into a consulting relationship with Bounce 21. These three guys became management consultants for Bounce 21, the majority member LLC, the majority member of Bounce 21 LLC, which in turn owned a majority of New Lounge. The problem is that, as has been cited repeatedly, and they say, using all kinds of hyperbole, that I have exaggerated the claim, but it's not. Mr. Napolitano claims he was entitled to two things, in addition to his management consulting fees: a percentage of the revenues. And he states as a defense, well, I wasn't an owner. But the entire policy of the SLA with respect to percentage ownership, that's section the ABC 126 sub 1, but it says you can't get a percentage unless you go through the entire SLA process. So as a policy matter, for someone to come in and sue on an 11-year-old oral agreement that they should be installed retroactively as a partner subverts the SLA's function and renders it meaningless, because anyone could become a partner and receive a partnership share or a percentage of a liquor licensed establishment. And even if that was a right to make that claim, which I submit it's not, I submit that they have the right, Mr. Napolitano. The other two plaintiffs are actual members of Bounce 21, and therefore have the right to complain about management or money misspent. And their percentages are disclosed to the SLA and listed in an operating agreement.
Well, sir, with respect to your claim of illegality, right? That's essentially what this is, that this alleged oral agreement violated various provisions of the Alcohol Beverage Control Law, right?
Yes, sir.
Do any of the statutes you've cited under the Alcohol Beverage Control Law expressly provide that a violation will hinder or prohibit the offending party from pursuing contractual remedies?
Yes, in the same sense that I guess a bar exam doesn't say we're going to prohibit people, but there is a hurdle. In the same sense that a layperson can't come in and sue me 11 years later saying, well, I'm entitled to a percentage of your law firm's revenues, or I'm entitled to a percentage of a doctor's practice. There's a hurdle in between that involves a government scheme for who gets into that. And just to show you how important it is, just recently we have seen marijuana dispensaries which actually are favoring people with convictions. But since Prohibition, the state liquor authority hasn't just said, we're not just going to prohibit licenses to felons or review them.
Licenses, I understand, but the thing is he didn't really have a direct ownership interest, and he's claiming some percentage for his business consulting agreement. Don't we have to see how that plays out before we throw out
And I submit to you that if you're not an owner, you just say I'm a management consultant, you can't retroactively back your way in. And not to overstep my time, the other point is he's asserted a right of first refusal on any Bounce entity in futuro. And keep in mind the quote I read. The only three people to this agreement, well, theoretically, are Messrs. Silman, the plaintiff Napolitano, Benvenisti, and Bounce 21. Everybody else is just done for harassment purposes. The right of first refusal was defended on the ground that if the agreement had terminated within a year without a breach, as is required by the statute of frauds, there would have been total compliance, or there would have been compliance because it could have been performed in a year, but that's not true because the option extended forever. Even if the place on 21st Street was unsuccessful and closed, you still have to offer Mr. Napolitano, under his interpretation, could be 10 years later, could be 20, a right to invest in another one.
Okay.
And sorry for the oversight.
No, that's okay. Let's hear from the other side, and we'll give you a couple minutes on rebuttal. Thank you.
Good afternoon. May it please the court, Jason Matuskevitz on behalf of the respondent Vincent Napolitano. There might be more than one way to skin a cat, but you can't just throw it out the window and say you did it. There's a process that needs to be involved here. You need to have a record developed. If they believe that there was a violation of the SLA somewhere in here, they certainly haven't proved it yet. There's been no discovery just started, but at the time this motion was made, it was a pre-answer motion to dismiss, and there was essentially no proof in the record. Mr. Napolitano certainly didn't allege that he made an illegal agreement. The term "beg the question" used to mean to assume the conclusion, and the defendants just argue that this agreement is illegal because it's illegal. We're not trying to enforce an illegal agreement. We're trying to enforce an agreement that Mr. Napolitano made with Mr. Benvenisti to give him the money to buy a company, to buy a restaurant. If they went out and made the agreement illegal afterward, is that Mr. Napolitano's fault? There's nothing in the record to indicate that he did anything wrong. I don't...
What about counsel's claim that this 25% right of, or that this right of first refusal for any future bounce locations just has no time limitations on it? So, I mean, so it just goes on forever and ever. Is that a problem, or is that something that we have to deal with in discovery?
It's not a problem, Your Honor, because as a legal matter, it's capable of being performed in under a year. There's no guarantee that any bounce entity is ever going to be opened in the future. So there's essentially no contract to be performed. Only if and when it becomes an issue would it need to be performed.
Well, wasn't there one that was formed in Chicago during the course of this period?
There have been numerous bounce entities that have been formed without honoring this agreement.
Well, one of the arguments I understood your friend to make was that essentially the agreement was unenforceable under illegality because by virtue of the alleged terms of this oral agreement, Mr. Napolitano was given somewhat of an ownership interest here, and that would run afoul of, among other things, Alcohol Beverage Control Law, Section 126.
Yeah, they call it ownership, but it has no indicia of ownership whatsoever. He doesn't control it. He's not a member. He has no right to control it. He doesn't participate in its operation. He does nothing but give them advice when asked, if asked.
And for that, he gets a percentage?
Well, he gave them $125,000 to buy the company. That's why he gets a percentage.
So does that somehow make him a de facto member, the fact that he gave him money and now is getting a percentage from them?
Well, he has no voting rights in the company. He has no other rights under any of the, he has no right to participate in voting any issue that comes up with the company.
He's not involved in the day-to-day operations of the restaurants.
No, he's not.
And he doesn't have a salary,
No, he does not.
like the others.
Yes, correct.
So he just gave the money and now is trying to find a way to get that money back, or, he made an investment.
Yeah, so they went ahead and they took his $125,000 and they said, thank you very much for the money, but actually our agreement's illegal.
So have they ever paid him anything for his business expertise? Has he ever given any business advice that they've paid him for since this agreement started in 2011?
I know that they have paid him pursuant to the 25% agreement. I don't know the particulars of what management consulting he has actually done for the company. And that hasn't been developed.
And you haven't alleged anything about that in your complaint?
We have not alleged that they failed to pay management consulting fees that were due and owing. Correct.
Okay. Okay, thank you. We'll hear from the other side, okay?
Thank you very much.
I didn't cite it in the complaint, Your Honor, but they did. He got back his money, and in the complaint, they allege that all this time he's been paid management consulting fees. Same as Silman, same as Benvenisti, the younger Benvenisti. And all he's saying, well, I didn't have management control. That's the whole point of being a hidden owner that the SLA is attempting to protect us against. Now, whether it needs protection or not, we're not privy to the ideas that went on during Prohibition that caused the state of New York to say, we want to have a tight control over who is in the background controlling liquor licensed establishments. And,
I have to say, counsel, that the argument is most peculiar because the arrangement was fine until Mr. Napolitano alleged that there was fraud going on. There was no illegality raised. Everything was going hunky-dory.
Because he never asserted an ownership right. If someone comes in and suddenly says, I'd like you all to vote the way I say because I
Well,
decorated this
doesn't
courtroom.
this have to do everything with the fact that additional locations were scouted in Chicago and in?
No, this was years, as he says. They had been doing them because in the bar business, there are things called pop-ups, whether you do it at a festival like Government Ball or something.
You know what pop-ups are? You know what pop-ups are?
And my point being that in those, some of them are transient locations. Sometimes you do it in Montauk or in the Hamptons. And, they could be a freestanding location, but that's been going on for years.
But you're saying that he was an owner who wasn't consulted. I don't understand.
No. I'm saying he was a consultant who now wants to enjoy the benefits of ownership, which are, I put some money in, but it's not a loan. I'm going to get paid out forever. And that's the problem, because that's what the SLA, that's what the entire legislative scheme regarding liquor license establishments focuses on. Who is here? You have to disclose the money in. You have to disclose what their interest is. You have to tell who the SLA who's going to manage. And I just want to say practically, and I know that this court doesn't necessarily always worry about that, but think about what a judgment would look like if the trial court were to say, you know what, we find that Mr. Napolitano has been an owner since 2011. What does that do to the SLA? Can anyone
Well,
come
I
to
think
court?
we're way far away from that, because all this is a motion to dismiss to see if there's some kind of claim. I must say that after listening to both of you, I'm not really sure what was going on here, and I've also read the complaint, and I'm still not sure. But what I'm also not sure of is that the case is, dismissible for all the reasons you've raised, or we've got to go on a little bit.
And if I might say, that's why I don't think the case should be dismissed. I think those two remedies should be dismissed. I think he has a claim for management consulting fees.
Okay, we will certainly look at that. Thank you both very much, and have a nice afternoon. The next case for argument is River Cross Tenants versus Kovac. Kovac?
Good afternoon.
Good afternoon.
I'm Robert Grimble from Grimble and LaJudas for the appellant Kathleen Kovac. I'm sure you've all read the record.
If you would like, you can take off your mask.
A good idea.
Okay, yes.
Then I can put on my glasses so I can see.
Now you can put on your glasses, but unlike the other guy, don't forget it when you leave. Okay,
I'll keep it here.
Okay, thank you. Good afternoon.
Good afternoon. This is a Pullman action, and it was a motion for summary judgment pre-discovery that was granted, and that's what's being appealed. What's interesting in this case is that what is proved in the motion for summary judgment essentially is very limited. That notices were served, there's what amounts to be a notice to cure under paragraph 31 of the proprietary lease. The notice saying, oops, you didn't comply with the notice to cure, we're going to have a meeting. They had the meeting, they had the vote, they proved they had the vote, they proved they served the notices. That's it. They did not prove in the motion for summary judgment to any degree, let alone the high degree of proof that's required on a motion for summary judgment, any improper conduct. There is no affidavit from anybody that says, oh, she did.
Wait, what about all the testimony of the upstairs neighbor and the downstairs neighbor of all the times their sleep was interrupted and they were concerned because of her banging on the ceiling and banging on the floor? What about that?
There is no testimony in the record. It is recited repeatedly in counsel's affirmations. It's recited in the notices. There is no affidavit from the tenant that is supposedly affected, or from any of the tenants that are supposedly affected.
Transcribed?
No, there's no trial in this. No, this was on a motion for summary judgment. This is on a very early motion for summary judgment.
Wait.
At the court board.
Yeah, didn't we read something where one of the tenants said, we're married, we have 2 children, and they're terrified because of the banging on the door, the banging and the cursing and so on at 7 in the morning. Wasn't there testimony somewhere, somehow?
There has been no testimony whatsoever. There have been no depositions. There was no trial.
Wait.
Just
Mr. Grimble, this is, I have to work this out of my head a bit. This is a Pullman action.
Correct.
We have to take a step back and see, did the board properly exercise a business judgment rule to terminate your client as being a nuisance in the building, correct?
That is one issue.
It's just, well, the principal issue.
I'm arguing that some of those.
Just so that we have to understand that. Now, pursuant to the proprietary lease, they had to take certain steps to afford your client a certain process. You don't challenge that. You don't challenge the notices. You don't challenge the initial notice pursuant to the proprietary lease that lists about 21 or 23 incidents of nuisance behavior. You got a second notice that listed 41 instances of nuisance behavior. Then, bear with me, there was a special meeting pursuant to the rules that was set up. You were successful in getting an initial stay in your initial action. Then that that stay was vacated. Then they commenced their ejectment action. And the ejectment action consists of the record that was developed by this board. And as I understand it, if I'm mistaken, correct me, Mr. Grimble, but there was a transcript of that special board meeting where the tenant at 1411 and the tenant in 1211 had an opportunity to, we call it testify, but to speak before the board and describe the various 21, 41 instances, correct?
Not exactly.
And you were there with your client listening.
I certainly was not there, but.
Well, somebody was there with your client.
Somebody was there. However.
And your client had an opportunity to speak to the board as well, correct?
Yes.
And then after they heard all that information, which was transcribed, they got together and held a vote pursuant to the business judgment rule and determined that the lease should be terminated, and that's why we're here today. And you're saying that that whole process is flawed.
Among other things, the process is flawed. B, that's not an accurate recitation.
Okay, then you can correct me.
I say they proved they served the notices. No question. They had the meeting. They rendered a decision that terminated the lease without saying why. Okay. There is not a single affidavit. The testimony, so-called, that you're referring to, was not testimony. It was unsworn and there was no cross-examination. Ms. Kovacs could not ask any questions. Her attorney could not ask any questions. And if you read the very beginning of that transcript, it's very clear that the board's mind was already made up. They were going through the steps. Now, I would like to continue if I may.
Well, you have 1 minute, that's all.
Thank you. If you affirm this, you are basically saying that a co-op can terminate a lease without any review of the propriety of their actions, because here you have no proof of any of the actions. There is, despite saying that all of this stuff, and it's in business records, none of the business records were produced. Ms. Kovacs put in her affidavit, and she demonstrated that she made a number of good faith complaints, and that after decades of this 70-some-year-old woman's tenancy, they finally are saying, well, okay, we're going to terminate your tenancy. She's saying retaliatory eviction. She didn't get discovery to go and to develop that. So if you are going to say that the board can, all they got to do is serve the notices, they can say whatever they like, they don't have to prove the content. They can serve the notice to cure without doing that. They can serve the notice to terminate. They can have a board meeting and do whatever they like. They go in the back and they come out and they say, we held a vote, your lease is terminated, and we're not going to say which action you did, which action you didn't do. If you want to say that the co-op has that arbitrary power, every co-op in the city can go out there and serve the notice, notice to cure, but the tenant doesn't have an opportunity in a court case to say, I did cure.
Okay, let's hear from your adversary, and then we'll be happy to give you a few minutes to respond. Thank you.
May it please the court, Bruce Wiener for Respondent Rivercross Tenants Corporation. This is a garden variety Pullman case. The last 20 years, the Court of Appeals has authorized the very procedure that Justice Schulman outlined. This court repeatedly has affirmed those actions by co-ops. In the Lapidus case, in the Weitzner case, where Justice Kapnick was the judge below, and this court affirmed the finding that the lease was properly terminated. Mrs. Weitzner was doing almost the same things that are alleged here by Mrs. Kovach, yelling, banging on the walls, cursing. Here, she went down and banged on the people's doors in the middle of the night. Yes, Justice Shulman, 23 incidents and 41 incidents after she was warned. This woman had it in her power to stop. She cannot stop. She continued this conduct even after she got a TRO from Justice DeAugust. She continued this conduct even after the meeting was held, where there was a full transcript. This co-op went above and beyond any other Pullman case that I'm familiar with, including the Pullman case itself. The same lease provision as in Weitzner, 31F of the proprietary lease, here it's a board decision, not a shareholder decision. And in Weitzner, this court affirmed a board vote pursuant to the proprietary lease. It doesn't have to be a shareholder vote. The proprietary lease in the Pullman case said it had to be a shareholder vote, and there it was 100% of the shareholders, other than Mr. Pullman, who voted to terminate his lease properly because he made the same kind of threats, physical threats against other shareholders that Mrs. Kovach has done. As the lower court found here, she terrorized these shareholders above her and below her in the middle of the night. There were 2 young children who were terrified, exactly what they testified to at the board meeting. They were all given an opportunity to be heard. There is no Pullman case in which a shareholder is given a right to cross-examine the shareholders or have their attorney cross-examine the shareholders. It's a fact-finding endeavor by the board to hear both sides. Mrs. Kovach was permitted to speak. Her attorney was permitted to speak. There was a vote taken after due deliberation by the board. And again, I repeat, this was all within Mrs. Kovach's control. She could have stopped after the first notice. She could have stopped after the second notice. She could have stopped after the TRO. She could have stopped after the board meeting, but she could not stop. There were repeated complaints by the shareholders above and below that this conduct continued. She blamed them for these fumes that she claims existed. She said they will never sleep because they're causing her these fumes that she also blamed on the co-op. So she was given all due process. There's no right to cure in a Pullman case. Mr. Grimble has not cited a single case where there was a right to cure. This is in the nature of a nuisance. There's no right to cure here. And these were not notices to cure. Much of what Mr. Grimble put in his brief, as he was retained to handle the appeal, didn't occur below. The arguments were not made below. They're made here for the first time, that this is a group of investors trying to evict Mrs. Kovach. This was a Mitchell-Lama co-op that went private 10 years ago. This is not, there are no sponsors here. There are no holders of unsold shares. There are no investors here. This is now an ordinary private co-op, but it was started out as a Mitchell-Lama co-op when she first bought her apartment. So these are all fabricated arguments on appeal with no record references at all. So this court should definitely affirm the finding below. The business judgment rule is in play. The court must defer to the legitimate actions of the board of directors. Thank you.
Thank you. Yes, you have 2 minutes. You may respond.
Thank you. The problem with counsel's argument is, in a motion for summary judgment, you got to have affidavits or documentary proof to demonstrate something. There's no affidavit saying, Ms. Kovach did this, Ms. Kovach did that. It's not there. They put in an affidavit from Mr. Kaufman, another attorney, who is apparently on the board. He doesn't say he lives in the building, whatever. He doesn't claim to be a witness. He doesn't say, I saw it. He doesn't say it happened. There's no affidavit saying it happened. There's no business record. You go from a notice to cure that says, which I call it a notice to cure because the proprietary lease says that if you don't stop after this notice under paragraph 31F, then they can do it. That sounds an awful lot like a notice to cure to me. When the notice to cure says you're making too much noise, the notice to terminate said, well, what you did is you made a lot of complaints which were groundless, and then you wouldn't let the staff into your apartment, none of which is documented by any fact. And Ms. Kovacs tried, she got a report, and it said search for reports, and there's no other report there about complaints to the staff. The fact is that on a motion for summary judgment pre-discovery, they got to prove things with affidavits on personal knowledge, documentary proof or something. Mr. Weiner saying something in a very, very convincing and sincere matter is not a substitute for letting my client have discovery on her issue of retaliatory eviction. And again, the right to cure under RPA PO 753-4. Again, that there is no court has ever said that's not available in a co-op situation.
Yeah, but there's no requirement. First of all, the notices are not notices to cure under the proprietary lease. And in a nuisance case, the case law is well settled that there's no right to cure.
Except that their notices specifically say you are violating the lease. They don't say you're creating a nuisance. People are stuck with the notices in eviction proceedings of any kind. That if the notice says this, that, and again, there's no affidavit that said she created a nuisance. The question is, how much can you review what the board did, or is what the board does sacrosanct?
Okay, counsel, I think we got your point. You made it clearly, both sides have. We will look at this again, and thank you both very much for your time this afternoon. People versus Juan Carmona. Good afternoon. You may proceed.
Good afternoon. Good afternoon, Your Honors.
You can take off your mask if you'd like.
It's okay, I'd keep it on.
Okay.
Thank you.
Speak up.
I'll do my best.
Okay.
My name is Ivan Pantoja, and I represent Mr. Juan Carmona on this appeal. We respectfully request that Mr. Carmona be adjudicated a risk level 2 offender because the lower court inappropriately relied on factors, circumstances that were already taken into account multiple times by the RAI. First, they were taken into account by risk factor 9, which specifically states that certain level of points would be attributed to the number and nature of one's prior crimes. In fact, Mr. Carmona was given the maximum number of points, 30 points for that risk factor. Now, I think it's important to note that there's only 3 risk factors that allow that amount of points.
The counsel of RAI factor 9 allows 30 points for a single prior sexual offense conviction, and here there's 4 prior forcible touching convictions within the past 10 years. So under those circumstances, isn't the board allowed to escalate? Isn't the court allowed to escalate?
Well, my argument is
Upward.
that, I'm sorry?
Upward.
Yes, I understand your question. Our point is that because risk factor 9 specifically states number and nature of prior crimes, that the board gave that amount of 30 points, which is the most amount of points that you can get in any particular risk factor, for those considerations of multiple convictions. But I would also note that in Mr. Carmona's case, his prior forcible touching convictions were also considered because they were necessary predicates to one of his convictions. The conviction for forcible touching were necessary for his conviction of sex abuse, when you have to have a certain number of prior forcible touchings in order to be guilty of the felony. Thirdly, the RAI also takes into account what's called a predicate sex offender designation, which also accounts for the prior forcible touching convictions. The designation, in effect, makes it so that Mr. Carmona has to register for the entirety of his life based on the prior forcible touching convictions. Lastly, I would also say that, you know, my friend's argument in that, you know, his prior failure to register his address as a prior level 3, he was a prior level 3 based on the misdemeanor forcible touching conviction. But there was no clear and convincing evidence presented regarding the circumstances of that case. And I think it's critical to note that that was an attempted failure to verify his address. So there was no indication, for example, that it was a willful evasion or some kind of willful intentional act to try to avoid detection, as the prosecution argues. Now, his prior level 3 adjudication, I know Your Honors may give some pause to that prior level 3 adjudication for the misdemeanor forcible touching, but I think it's important to note that the SOAR determination hearing should be based on the facts of the time, based on that particular conviction for that particular case. It is not uncommon for individuals to have different risk factor adjudications based on different crimes at different times. So our position is that he was appropriately categorized in the number total as a risk factor 2, and it was inappropriate to upwardly depart to a level 3.
Okay. Thank you, counsel. You'll have a minute on rebuttal. Good afternoon.
Good afternoon, Your Honors. Andrew Chung for the people, and may it please the court. I'd like to begin by reiterating the serious nature of the defendant's crimes. For the 5th time within a span of 6 years, the defendant committed a sex crime, this time coming up behind an individual on the busy streets of New York, locking her from behind in a bear hug, groping her breasts, and rubbing his erect penis in between her buttocks. For this, the defendant was convicted of first-degree sexual abuse, persistent sexual abuse, and forcible touching. At the SORA hearing, Justice Farber granted both the board's and the people's request for an upward departure, and we would ask that you affirm this holding. As a preliminary matter, the risk assessment instrument notably does not take into consideration a defendant having multiple prior sex crimes, as Your Honors pointed out earlier. The defendant would have received the same 30 points under risk factor 9 had he committed 2 or 20 or 200 prior sex crimes. Indeed, this court has held in cases such as People v. Cruz and People v. Sostenes that prior sex crimes can indeed serve as an aggravating factor that the SORA court is warranted in relying upon when deciding whether to grant a departure. In addition, the defendant has already been adjudicated a prior level 3 sex offender, and he would remain so even if the court were to grant the defendant's request here today. The defendant, following his second conviction in 2009 for forcible touching, was adjudicated a level 3 sex offender, and despite this, he went on to commit 2 more sex crimes in 2011, and his most egregious crime to date, which is the case we're all here today to hear. Notably, this court has also held in cases like People v. Grassi that a defendant going on to commit further sex crimes despite a prior adjudication bears on an individual's risk of sexual recidivism. Finally, the defendant also has a conviction on his record for an attempted failure to verify his address as required of a level 3 sex offender. Notably, this court has held in cases such as People v. Cushney that a defendant failing to conform his behavior within the dictates of the law despite having prior reporting obligations is also an aggravating factor that the guidelines don't take into consideration. Finally, in his papers, my friend on the other side points out that the defendant's age should serve as a countervailing factor under the 3rd step of the Ghilotti analysis. And we would argue that this is not the case. Notably, the defendant committed all of his sex crimes past the age of 40, and his most serious sex crime to date at the age of 52. So it's clear that the defendant sexual behavior is not abating with age, it is actually escalating. For these reasons, we would ask that you affirm the SORA court's holding, and if there are no further questions, we would rest on our papers and ask that you affirm. Thank you.
Thank you, counsel. You have 1 minute.
Thank you, Your Honors. In regards to the argument that if he had 10, 20, 200 prior forcible touching convictions, That would certainly be a completely different factual circumstance that would result certainly in an override if a person had that many convictions.
Well, it seems to me that this case has a lot of similarities to the People versus Cruz case that was decided by this court 2 years ago, which your adversary did make reference to, where there were 4 prior convictions, and there was a feeling by our court just 2 years ago that this would not be adequately taken into consideration by the risk assessment instrument. So, I mean, I don't want to downplay that. I don't really see how this case is too much different from that case.
Well, Your Honors, our office represented the appellant in that case, and there are significant factual distinguishing factors from our case. First, the defendant in Cruz had 4 prior felony convictions. Mr. Carmona has 1 prior felony conviction from 40 years ago. Secondarily,
he does have 4 forcible touching convictions, so that's a concern also that wouldn't.
Absolutely, Your Honor, and I don't want to downplay the seriousness of the acts here. Certainly serious, certainly result. He should be registered as a sex offender. He should be a level 2, and his designation, he should register for life. That's not in dispute. And another factual distinction between this case and Cruz is that the recency of the prior felony or sex crime in Cruz was within 3 years. The defendant in that case committed that felony or sex crime within 3 years of the offense that resulted in the SOAR registration. Mr. Carmona was not given points for that risk factor. So those are, the 4 prior felonies, the designation here. I would just ask Your Honors to adjudicate him a risk level 2, and thank you for your time.
Thank you very much. And finally, we have one attorney here for Robbins, and we've given you a few minutes to speak. 3 specifically.
Good afternoon, Your Honors. Thank you for allowing me to argue by myself here. My name is Jacques Simon. I represent the appellant in this case. And I want to summarize it really quick. This case is a case of where's Waldo? Where are the medical records from the hospital? Where are the medical records from the EMS? Where are the supposedly slides, the microscopic slides that Dr. Prial read? Where are the slides, the dissections that she took from the lungs or from the tissues that she weighed back on September 26? The answer is nowhere in the medical record. So when there's nowhere in the medical record, you cannot find those in the medical record. If we go page by page by page by page, Dr. Prial initially specifically checked that she made a histology slide jar, and she specifically checked the box that she does not need slides. And then when you look at, in the record, at the page where the inventory, the autopsy inventory is, she specifically states that she does not need slides, she does not check anything, that she needs slides in order to demonstrate the case. So what does she do? She starts with the premises that because the decedent received ozone therapy, this must have caused the death. So now, as soon as she receives the case, she's on a crusade to prove it. And here is how she does it. First thing she orders, first order of business. By the way, the record has 3 parts to it, the administrative record. The first part is Dr. Prial's notes. The second part are the case notes. In the case notes, everything that gets done gets entered. Anybody who has anything to do with the file has to register their activity in the case notes. Why? Because if there's a criminal case, they gotta refer it to the district attorney subsequently. So these things don't just exist in a vacuum. So we gotta really, unfortunately, follow step by step what Dr. Prial did. So when you look at the medical record, there's 2 parts of the medical record time-wise. One starts in September 26, 2019, when she receives the case, supposedly as a referral from somebody called Dr. Hackensmith, who doesn't exist. There is no record of Dr. Hackensmith. If you check if you take judicial notice and you go on the OPMC or the DOH site and check, and it's in the record, and check the record for Dr. Hackensmith. There's only one Dr. Hackensmith in New York State, and he was not licensed to practice medicine until a year later. That's assuming there was Dr. Hackensmith. But there was no Dr. Hackensmith at the time when they received a referral from Mount Sinai. Most importantly and most disturbingly is the fact that the Mount Sinai records are not in the administrative record. And they say, oh, we are protecting the...
Go ahead, you can finish your...
We are protecting the identity of the patient. And we have a court order that protects the identity of the patient and everything is sealed. Something just doesn't make sense. There are no histology slides. There are 10 months. There's a 10-month gap during which Dr. Prial said that she's studying the record and she did nothing to pathological study the record. Most importantly, at a footnote in her survey platformation, she gives us an idea of what it takes to create the slides. They don't just appear by osmosis in the record. They gotta go to the histology lab, there's a chain of custody, and if you compare the request for toxicology, which she made on the 26th of September, there's a whole sheet that she has to check things in. There's nothing in the record where she checked a request for histology slides. There is in the record the fact that she specifically said not to make up histology slides. All of a sudden, 10 months later, the histology slides appear in two places. One is on July 7, saying that the deputy director of OCME, that's the second in charge, read the slides. There is no report from him. That's Dr. Prial's note. There's no slides for him to read. There's no slides for her to read. There's no rational basis for anything in her findings. Negligent homicide cannot be found by conjecture and surmise. So what she did was she ordered x-rays to look for emboli, okay? If you look in the case notes, it tells you where they took x-rays, not only of the heart, but of the whole chest and the abdomen. There's no interpretation of the x-rays. There is, on her notes, there is a note that she asked for an x-ray consult. There is no x-ray consult. So she comes over to explain that, even she admits that when she did the x-rays, she read the x-rays herself, and there's nothing in there to show emboli. So when she was at the law school that she didn't find emboli, she didn't know what to do. So what does she do? She orders a toxicology report, thinking that she's going to find proof of emboli in there. She doesn't know that she can't find proof of emboli in the toxicology report. This is a case of first impression for Dr. Prial, apparently, because she doesn't know where to begin. The toxicology report comes back, and then in her survey platform, she said, oh, I learned from the director that you cannot find emboli in the toxicology report. The toxicology report does not show any emboli. The only thing that shows emboli is Dr. Prial's word, which is outside of the record. Everything that the Supreme Court did was to consider Dr. Prial's affirmation impermissibly outside of the record, which does not explain the record, but puts in a lot of factors that are missing and which Dr. Robinson's expert said that's missing, who was the head medical examiner for Rockland County. Thank you.
Okay. Thank you, counsel, and have a good afternoon.
Thank you so much.
Take care.